Acceptance is nothing more than to receive something, to take something. When an offer is made, the next thing is for acceptance to be made. So, very quickly, what then is acceptance? Acceptance, legally speaking, is the willingness, is the voluntariness, is the positive, unqualified, unconditional indication or assent to be bound by the terms of an offer upon which a contract is brought to being. That is to say, if I give you, for instance, this phone, giving you the phone is me making you an offer. For you to accept it, or for you to, yes, accept it, is you receiving this phone from me. And the law says what qualifies as acceptance is unconditional, is unqualified. That is to say, that I'm offering you this phone. In accepting it, you will not come to say, give me the phone with charger, or I will not take it. If you ever make a condition like that, the law says it is not acceptable, it is not correct, it is not going to be. That is definitively what acceptance is. You can look at the very good case of BCC and Sky Rich Inspection Nigeria Limited. I beg your pardon, BCC and Sky Inspection Nigeria Limited, to further get the definition of an offer. You can also look at the case of Orient Bank and Belante. You can look at the case of Khalil and Carbolic Small Boards. Let us quickly now look at the features or the principles guiding acceptance. Just like we talked about the very good features or the very fundamental features of offer in my previous video, there are also in the same vein some salient features that guide acceptance. Number one is that an acceptance must be communicated. In fact, in the body of contractual agreements, in the body of law, one cardinal and fundamental issue or factor that runs across every legal obligation is communication. From the moment you have accepted somebody's offer, that person you have accepted his offer must be communicated. The person must be aware that you have accepted to be bound by the terms of his offer so that he can know that contract has come to be. And acceptance must be very clear. Your acceptance must be plain. You must communicate acceptance in the way that it is understandable. You don't need further interpretation for it to be construed, for it to be explained that you have accepted. If an offer was made expressly, acceptance should also follow expressly. The communication should be in the same spirit. If made impliedly the same way, subject, however, to the terms of the agreement or the contract. The next feature to take away from acceptance is clarity. I talked about it when I was discussing communication. The term of acceptance must be clear. It must not be vague. It must not be riddled with ambiguity. It is not something that somebody has to crack his brain to now decode that you have actually accepted the offer. No, it must not be something like that. All right, offer must also be unqualified. Sorry, acceptance must be unqualified. I beg your pardon. What it means for an acceptance to be unqualified or unconditional is that if somebody is giving you, is offering you, say, a two-bedroom duplex, say Mr. Aribe Sola is gifting or is offering Mr. Kennedy Okonkwo a two-bedroom duplex. Say, take. Mr. Kennedy Okonkwo, being the offeree who is supposed to accept the two-bedroom duplex, must not say, I cannot accept it unless it is painted, unless you fix CCTV camera. Once you introduce any other term, any other clause that is not the original clause or terms of the offer, the law says you have varied the original offer, and that does not amount to a valid acceptance. So acceptance must be unconditional. It must not be qualified, right? So another feature there that, of course, is very cardinal, is very primary to um, acceptance is that acceptance must be communicated within a reasonable time, and acceptance must be done within a reasonable time. If the contract does not stipulate a particular time within which it is supposed to be accepted, if the offer does not communicate a particular time within which it's supposed to be accepted, then acceptance must be made within a reasonable time. What amounts to a reasonable time, or what the law will interpret to be a reasonable time, depends largely on the circumstances of the contract. At this point, I like to drop an assignment question. It is my custom, it is my way to always drop assignment question for my students who especially are in Clifford University. The first assignment question is this: the validity of acceptance is predicated on the existence of extrinsic evidence from which the court can infer a properly communicated assent by the offeree. Discuss the above assertion with decided cases. I will take it again. The validity of acceptance is predicated on the existence of extrinsic evidence from which the court can infer a properly communicated assent by the offeree. Discuss with decided cases the above assertion. All right, very quickly, let us look at the requirement of a valid acceptance. For an acceptance to be valid in law, are there some requirements? If there are, what are those requirements? When you look at the case of King Nigerian Limited and BH Nigerian Limited, the court says that acceptance must correspond with offer, meaning it must not vary, it must not negate, it must not negatize, it must not thwart, it must not alter the form, the substance of the offer. An acceptance must be unqualified. It must be in line with the offer that was made. Okay, very, very key. For instance, let's look at the case of Major General George Ine and others and Ferrado Agro Consortium. What happened in this case? Or let us also add it with the case of Orient Bank and Belante. But then cardinally, let us look at the case of Hyde and Wrench. The case of Hyde and Wrench, the same way, almost the same fact, the same circumstance in the case of Orient Bank and Belante, and in the case of Major General George and Ferrado Agro Consortium. Now let's look at the case of Hyde and Wrench. What happened there? Somebody offered to sell his estate for the tone of £1,000. He made the offer to the offeree. The offeree accepted to buy the estate, but said he was going to buy for £950 instead of £1,000. You see that the acceptance of the offeree does not correspond with the offer of the offeror. The offeror said, I am selling for £1,000. The offeree said, I will buy, but I will buy for £950. And the law says, if you must accept an offer, your acceptance must correspond with the terms of the offer. At this point, I give a second question for my student. The second question is this: kindly report the facts of the cases below and the decisions of the court. Report the fact of the cases below and the decisions of the court. Number one is the case of Orient Bank and Belante. Number two is the case of Major General George Ine and others and Ferrado Agro Consortium. Number three is the case of BFI Group and Bereau of Public Enterprise. BFI Group and Bereau of Public Enterprise. Briefly report the fact of these cases and the decision of the court in the cases above. Now, the next thing to talk about is when conduct in affirmation of counteroffer will amount to a valid contract. When conduct in affirmation of counteroffer will amount to a valid contract. You can look at the case of Council of Yaba College of Technology and Nigerian Niger Contractors, yes. Council of Yaba College of Technology and Niger Contractors. Look at that case. Look at the case of Nigeria Dynamic Limited and John Agoha. Those two cases actually answers that question. When conduct in affirmation of a counter offer will amount to a valid contract. The question now is, what is a counter offer? A counter offer, ordinarily speaking, is an acceptance that is qualified or an acceptance that is conditional to an offer. When, like in the case of hide and wrench, the offeror, the defendant, wrote the offeree, the plaintiff, say, I want to sell my estate and I'm selling for £1,000. And the plaintiff offeree accepted to buy the estate, but he made a proposal to buy for £950 instead of £1,000. At that particular instance, the law says that variation, that was made to the original offer, to the terms of the original offer, cancels that original offer and consequently has made a counter offer. So counter offer, you can define it to actually be a varying acceptance of the original offer, a qualified or a conditional acceptance of the terms of the original offer, which cancels the original offer and creates a consequent offer known to as counter offer. In this instance, the original offeree now becomes the second offeror, and the original offeree may, if he accepts the proposal, the varying proposal of the original offeree, he now will become the offeree. I hope I did not confuse you. Like in the case of hide and wrench, remember party A said, wrote to party B, I want to sell my exit for £1,000. Party B said, I am going to buy. He accepted to buy, but he accepted to buy at the rate of £950. So party B varied the terms of offer of party A. And so that thing party B did amounted to cancellation of the original offer of party A and also gave rise to a counter offer flowing from party B to party A. So party B, the original offeree, by reason of the counter offer, now becomes the second offeror. And the original offeror, if he accepts the offer of the original offeree, will now become a second offeree. Very quickly, believing that you have understood this, let us look at conditional acceptance. What does the law see or refer to as conditional acceptance? In some contract document or at some contract agreement, you will see when parties will put in clauses like subject to contract, like no engagement or tentative engagement, tentative acceptance without engagement. Or you see something like provisional acceptance or provisional offer. These kind of clauses amount to what the law refers to as conditional acceptance. It is a situation where somebody accepts an offer but gives a clause to it to say until XYZ is done, there is no full contract. Now, I'm going to use some cases to actually buttress what conditional acceptance is all about. Generally speaking, you must know that conditional acceptance is actually not really allowed, not really, valid in law. I want to use that language. Generally speaking, conditional acceptance, it does not really create, a valid contract. But there are some times when conditional acceptance can really create a valid contract. Now let us look at, having discussed what conditional acceptance is, let us look at the legal effects of conditional acceptance. Number one legal effect of conditional acceptance is that it does not give rise to obligations and duties. It does not create reciprocal rights over the contract. So any agreement that is made subject to contract on clothes, it removes, all right, the necessary rights and obligations that parties are supposed to enjoy ordinarily in that particular contract. Another um, another significance of a conditional acceptance or contract made subject to or agreement made subject to contract is that it gives parties more time to deliberate whether or not to be bound by that contract. Very quickly, let me look at the case of Chief Obaseki and ACB. Chief Obaseki and ACB. In this case, the mortgagee actually hired an auctioneer, a licensed auctioneer, to sell off some mortgage property. All right. But there was an instruction given to the auctioneer. And that instruction was that no matter the sales of this mortgage property to the highest bidder, that a valid contract will not come to being until there is an approval by the mortgagee. And the fact of this case of Obaseki and SCB details that reasons for putting in this subject to contract is so that the mortgagor, the original owner of the property, could be notified that that property is to be auctioned and all that. There was indeed a highest bidder. And at the end of the day, it was actually a landed property and documents were executed. All right. Documents we are drafted, but was not actually executed, owing to the fact that the mortgagee had left an instruction with the auctioneer that a valid contract would not have been created until he approves it. Now you see, the auctioneer had sold the property by reason of having gotten a highest bidder. And at this instance, they had actually drafted the deed of conveyance to transfer title in the property to the purchaser. But there was a clause tying down the contract, and that is the clause where the mortgagee, the principal to the auctioneer, said, I have to approve even if the person had paid full sum of money. This is a kind of scenario where an agreement made subject to contract may not allow parties to enjoy their reciprocal rights. This kind of issues or this kind of scenarios also raises conditional acceptance. That is to say, the mortgagee has accepted that the mortgagee has accepted the offer made by the purchaser to buy the property. But that acceptance was conditional, subject to his approval. That's what happened in the case of Chief Obaseki and ACB. If you don't get it clear in this particular area, please drop your question, drop your concern at the comment section. Take it from me that I am going to explain again and again until you understand. Very quickly, if you look at the case of Maja Junior and UAC, the same thing too, talking about conditional acceptance. Yet defendant's property fully paid for, was refused. Was refused to be accepted, and the court held that there was a subject to contract issue, and so nothing like a valid contract came to being. All right, if you look at the case of Odon Fonade and Ososami, Odon Fonade and Ososami, it's another very wonderful case there, where, of course, a a vendor had a property to sell, and there was an agent who indicated interest to get a buyer. We're looking at the fact of the case of Odon Fonade and Ososami. The agent approached the owner of the property to say, you want to sell this your property, I will get you a buyer. How much do you want to sell? The vendor said he was selling for 12,000 pounds. And then the agent said, no problems, I'm going to get a buyer, but please, whatever extra amount of money on the 12,000 pounds is not for you, that will be my commission as the agent. Now they executed an agreement, and even when the owner of the property, the vendor, was accepting this arrangement with the agent, They executed an agreement, and the owner of the property wrote inside the agreement tentative agreement without engagement. Tentative agreement, tentative acceptance without engagement, meaning that he accepted the offer of the agent to sell his property for him. But if the property sells or sold for more than £12,000, the extra money was going to be his own. Now, what actually happened in that case? There was somebody who was interested to buy the property, the purchaser. Now, the agent introduced the purchaser to the vendor. What the vendor did was to go behind the back of the agent and transacted with the purchaser, sold that property for £25,050 and refused to account for the excess of the sales to the agent. The agent plaintiff sued, and the court held that there was no valid contract because of the presence of the clause tentative acceptance without engagement. So these are how conditional acceptance can play out. Let us now look at cross offer. What is a cross offer? We have talked about offer in our past video. This lecture series, we're talking about acceptance actually. But in between, there is something like counter offer, there is something like cross offer. We have talked about counter offer. Now let's look at cross offer. Cross offer is actually that type of offer whereas two parties are making the same material offer simultaneously at the same time, but without knowledge of the other or the either party's offer. That is, party A had a car to sell, and party B has always wanted to buy party A's car. And then somehow party A got the knowledge that party B is interested to buy his car. And so party A, who owns the car, the vendor, wrote party B to say, I'm selling my car for 50 million naira. And at the same time, too, party B wrote party A to say, please, I'm interested in buying your car. I learned you want to sell. I am offering to buy for 50 million naira. And the both offers from party A who wants to sell and party B who wants to buy, the both offers crossed to each of them, to either of them, simultaneously at the same time. The law calls it a cross offer. It is an offer made by two parties to a contract without the knowledge of the either of them. And then in law, two offer cannot amount to a valid contract because there has to, as a matter of fact, be offer and acceptance. So one offer, another offer simultaneously crossing path does not amount to an acceptance. It's just like you saying two wrongs cannot make a right. Two wrongs cannot make a right. It's just like in physics, or in the electronical or electrical engineering field, you say negative cannot produce light. Positive cannot produce light. In the same vein, in the same spirit, offer cannot amount to acceptance. So two offers crossing paths amounts to nothing but a cancellation of offer and nothing more. You can look up the case of Fitch and Snyderker. The case of Fitch and Snyderker. Fitch and Snyderker. You can look at also the case of Thien and Hoffman. The case of Thien and Hoffman. Let us at this juncture look at acceptance in ignorance of offer, where the case of Fitch and Snyderker is also an authority. The case of Fitch and Snyderker is also an authority in the subtopic of acceptance in ignorance of offer. When we say an offer was accepted ignorantly, what do we really mean? It is just summarily when a party to a contract accepts the offer of a contract without knowing that there was actually an offer made, or when a party performs the duty required of a contract without knowing that that was a reward or there was a formal offer made, that he would have benefited from. It's just like looking at the case of Khalil and Kabalik smoke ball. All right. So example is this, and this type of acceptance in ignorance of offer usually occur under unilateral contract. For instance, if let's say Mr. A is looking for his motorcycle and he makes an offer to the world to say, anybody who is able to find my motorcycle and return it to me, I will give the person the sum of 250,000 naira. Unknown to party B, let's say Emeka Chukwudike, unknown to Emeka Chukwudike, that Mr. Arigbesola, who was looking for his motorcycle, had already made an offer, a promise of 250,000 naira to anybody who is able to return his missing motorcycle. Unknown to Mr. Emeka Chukwudike, all right? He sees Mr. Arigbesola's motorcycle, recognizes it. You know, this motorcycle belongs to Mr. Arigbesola. What is he doing here? Let me take it back to him. And he carries Mr. Arigbesola's motorcycle and gives it back to him. Maybe getting to his house, he was not there. All right. He packed it for him and left. On getting to his own house, Mr. Emeka now realizes, maybe hearing the news from a friend, that there is a 250,000 naira bounty on anybody who returns this motorcycle. Whereas he had already returned it before getting to know or becoming aware of the offer made in that instance, or on the return of that motorcycle, on the performance of that action. The law refers to it as acceptance in ignorance of offer. So it does not amount to a valid contract. It cannot amount to a valid contract. That's what the law says. You can also look at the case of Williams and Cowarden. The case of Williams and Cowarden. Very quickly, we have talked about communication as one of the features of acceptance. Communication is very, very important as far as acceptance, you know, is concerned. Let us look at whether there are situations where communication might not really be necessary in law. Are there times when communications might not be necessary, when acceptance comes to play? Yes. For instance, there are two exceptions. Number one, waiver, and number two, acceptance by post. Under these two situations, communication of acceptance is not really necessary. The waiver has to do with when an action is required to say that a valid contract has come to be. So, like in the case of Kali and Carbolic Smoke Board, in the case of Fitch and Snedeker, under the circumstance of unilateral contract, all right, when a unilateral contract is made, when an offer is made, what is needed of the other party is the performance of that action. That action is what amounts to acceptance. So the person do not need to communicate to the offeror in this situation that he wants to perform that particular action. So it is the performance that is acceptance. And so because you only performed it, communication is not necessary. So this is an area where in law, communication of acceptance is not necessary. The next area is under acceptance by post. Generally speaking, acceptance by post in law is when the notice, the letter of acceptance of an offer is posted into a post office, regularly, the way it's supposed to be. So it means that if Mr. A is the offeror, writes Mr. A to say, I want to sell my Lamborghini, I want to sell my Ferrari, I want to sell my Range Rover Sports. Okay, if you are interested, please let me know. And the offeree, party B, writes his acceptance and put it in a post office to send to the offeror. The law says immediately that letter of acceptance is duly posted in the post office. All right, in the post, yes, acceptance has been communicated. And now over the period, this rule, which was actually popularized from the case of Adams and Linsell, started giving people issues, started giving people very, very big issues. It was, they saw it as very hard. It started orchestrating hardship You can also look at the case of Household Fire Insurance Limited and Grant, where somebody who had made an offer for um, shares did not know that he had been allotted shares. The letter of acceptance and offer of shares was posted into a post of by post, and the person never got it. It went missing, along the line. And the way that company finally came under liquidation, he was written, Mr. Grant was written to pay up the money for the number of shares allotted to him. When the matter came before the court, Mr. Grant argued that he was not communicated that his offer was accepted, and so he's not liable. And the court held that as far as a valid acceptance notice had been posted, via post office, communication was deemed to have been made to him. And so over the period, this rule gave, concerns. It meted hardship. And then by God's by God's grace, and of course by the event of cases that came up in the case of Ray London and Northern Bank, XP Jones, and several other cases, there were exceptions created for this particular rule in the case of Adams and Lindsay. Number one exception that was created from the case of Howell Securities and Hughes is that when the offeror indicates that acceptance must be communicated in writing, that rule in Adams and Lindsay will not apply until the offeror is communicated, in writing. So another exception there is where the address of the addressee, being the offeror, was wrongly written, that rule will not apply. And where the postal rules was not properly followed, it will not apply. The fourth one is where the application of the rule in Adams and Lindsay will cause hardship, the rule will not apply. Finally, let us look at the termination of offer. There are different ways an offer can be terminated. Number one is by revocation. Number one is by rejection. Number two is by lapse of time. Number three is by the death of the offeror. Number four, finally, is by the death of the offeree. We will take them very briefly, one after the other. What is revocation? Revocation is the withdrawal of the offer that was made by the offeree. Sorry, by the offeror, I beg your pardon. Revocation is the withdrawal, the taking back, the declination of the offer that was made by the offeror. That is to say, I want to sell my 2-bedroom apartment to Mr. B, and I told Mr. B I want to sell my house for 250 million naira. All right, so and please, I'm giving you 1 week or 2 weeks to accept the offer within the period where I am supposed to, where the offeree, the party B, is supposed to accept the offer. I am entitled in law, I am entitled by law to revoke, to withdraw that offer I made, to say I am no longer selling my property. Please, I have withdrawn that offer. It is valid in law. Revocation must be made before acceptance. Revocation must be made before acceptance. Otherwise, if the party to whom an offer is made has validly accepted the offer and communicated same to the offeror, revocation will no longer be valid. And then there is another instance where revocation cannot also take place. It is in the cases of contract that has to do with irrevocable offer. For instance, I said I was going to sell my 2-bedroom apartment to party B, and I gave him 1 month period to accept, all right, to pay up the necessary money so that I can sell my apartment to him. And party B, out of the 250 million naira I want to sell, for instance, has advanced 20 million naira. I am bound by law not to revoke that contract. I cannot revoke that contract until the time period of 1 month I gave to him to accept. That is when consideration has been given for acceptance that is yet to fully come. Now, what is rejection? Just as the name implies, rejection is to say, no, I am not interested in this contract. I'm not interested in the offer you have made. So If party A makes an offer to party B and party B rejects it, either by expressly or impliedly saying it orally or in writing that no, I am not interested, that is rejection. So an offer by this means will be terminated. Rejection can also come by reason of counter offer. And counter offer arises when an original offer is varied by the terms it was originally made. These would amount to rejection, and this rejection will amount to termination of offer. Lapse of time is just another way to terminate an offer. When an offer is made and is supposed to be accepted within a particular time frame, and the person does not accept that offer within that time frame, the law says the offer has lapsed. The time frame within which the offeree was supposed to have accepted that offer has lapsed. The person can no longer turn around to accept the offer that was made. So lapse of time can actually terminate an offer if it is a kind of contract or agreement that has a time frame within which it's supposed to be accepted. The death of an offeror can actually terminate an offer. Me who wants to sell my property, all right, if peradventure I die before the time or before the time that offer was accepted, then offer will ordinarily terminate. But there are circumstances where if it is a contract that can actually be inherited by the survivors, by the representatives, by the beneficiaries of the offeror, the law says that that particular offer will not terminate. That offer will run, and the representatives, whether personal or legal, the administrators of the deceased offeror, will still be bound by that offer. However, if it is a contract of service that required the personal and direct service of the offeror or the offeree, whichever way, then that offer terminates by the death of the offeror and the offeree. All that applies to the death of offeror also applies to the death of offeree. Ladies and gentlemen, this will bring us to the end of our lecture series on acceptance as another essential element of a valid contract. Don't forget, you are in the channel of Legal Playlist. It is an educational channel where we discuss every topic that has to do with law within the Nigerian jurisdiction. Of course, teaching you in ways you will understand. I am once again Emperor Kemjika Nnoma, a legal practitioner and a lecturer with Clifford University, Abia State. And Clifford University is a place to be. I charge you as much as you're looking for a place to study law within a serene and hygienic environment. I offer you Clifford University as that university you should think of to study law and get the degree of LLB. Please don't forget to subscribe to my YouTube channel, and of course turn on the notification bell so that you will always get notified whenever we post new lecture series content. If you have gotten value from this video, do well to drop comments at the comment section. All right, drop your comment at the comment section. If you have questions to ask, please ask your questions at the comment section. I will always attend to you. If there is anything you did not get clearly, please drop it at the comment section and we come back to attend to you. And you can also give us the inspiration to make further videos for the purposes of clarification. Until I come your way again, when we will be discussing consideration as another essential element of a valid contract. Thank you very much. Stay safe.